my lawyer a share of my business in exchange for their services rather than paying a bill? This is such a great question, but it's one where you really need a lawyer to advise you on your particular circumstances. That is, you'll need one lawyer to advise you on your relationship with your other lawyer. It's that level of convoluted. But this is a common enough inquiry with startups and other entrepreneurs for whom equity compensation arrangements are relatively common that I wanted to address it at a high level here. A startup founder figures, I'm paying my chief technology officer, marketing specialist, and CFO primarily through equity for services in lieu of cash compensation, so why not my lawyer? It's an appealing arrangement if you're short on operating cash and you can find a lawyer that's willing to agree to it. First, you and your lawyer, or lawyers plural, need to determine if this arrangement is flatly prohibited in your jurisdiction. Even where it's allowable in theory, an equity compensation arrangement for a lawyer is going to be governed by the rules and limitations of the State Bar Association on top of the terms that are negotiated and memorialized in the fee agreement and in the equity grant award. I mention lawyers plural, of course, because you'll be drafting legally binding contracts regarding the terms of the arrangement. Things like percentage of equity being granted, service requirements, vesting, whether the shares are voting or non-voting, conditions and restrictions on disposition, and so much more. And lawyers usually have a comparative advantage in that space. So you'd need a third-party lawyer, whom you're presumably going to pay on an hourly fee basis, to negotiate and draft the agreement with the equity receiving lawyer on your behalf, even if this is exactly the type of work that your equity compensated lawyer will be doing for you on a go-forward basis. Now, this could make perfect financial sense if the primary lawyer is providing significant services over an extended period of time, but you still need to be concerned about conflicts of interest. Now that the lawyer is an owner of your company, how have you and that lawyer mitigated the risk that the lawyer's equity interest will skew the lawyer's incentives and objectivity? The lawyer has a professional obligation to ensure his advice will be in the best interest of your company generally, and not just in the best interest of the value of the lawyer's shares at the time he wishes to dispose of them. But that can be more easily promised than achieved. So in answer to this question, in some jurisdictions, yes, you and your lawyer can agree to an equity compensation arrangement, but it is a high-risk proposition for both sides. The shares may wind up worth exponentially more than the per-hour value provided by the lawyer, or the lawyer could wind up with worthless shares and nothing to show for countless hours of effort. Before you proceed with this idea, be sure to get sound legal advice as to whether it's permissible at all, and you may want to follow up with your financial and tax advisors to make sure you've fully thought through all of those implications before proceeding as well. Business owners, would you be willing to grant your lawyer or other professional service provider shares of your company in lieu of payment?